Hi, everyone. So today, in this presentation, we're going to talk about how to properly quote and paraphrase language from sources in legal writing. And we're also going to talk generally about how to avoid plagiarism. So I guess you can think of this as a best practices sort of video when it comes to legal writing and how to use quotations and paraphrasing of sources. In a second video that I will record in tandem with this one, we'll talk about the actual mechanics of quoting sources in legal writing. So the first thing I want to do is talk about some key terms for you here. What does it mean, for example, to quote a source? Well, quoting a source means that you're borrowing language from a source and you're properly showing that the borrowed language is not your own. Okay, so that's what it means to quote a source. You're borrowing language from a source and you're showing the reader that the borrowed language is not your own. Second term is paraphrasing. What does it mean to paraphrase a source? Well, that means that you're putting language from a source in your own words. You're not borrowing the language. You are reading that language in the source and then deciding to sort of rework it so it's in your own words. So that's what it means to paraphrase. And then finally, plagiarizing means to fail to properly attribute the borrowed language to the source. So it usually means forgetting to put borrowed language in quotation marks. That's what we're talking about. It also means that you might fail to cite the source for the reader. And then we're not going to delve too deeply into citation today. We'll do that in future classes and in future exercises and assignments. But we will touch on citation and when it's appropriate to cite a source. So let's focus on avoiding plagiarism first. How do you do this? How do you prevent yourself from failing to properly attribute language that you are taking from a source, failing to attribute that to the original writer? Well, so for borrowed language, in other words, language that you're taking directly from the source with little to no alteration, the first thing you need to do is put that language in quotation marks. Unless the borrowed passage is 50 words or more. Okay, and that's going to be a very rare circumstance that you would have a quote that long, which we'll talk about the reasons for that in a moment. If you do have a circumstance where you are going to quote a passage that's 50 words or more, you're borrowing that long of a passage, then you would have to, first of all, single space that passage. And second, you'd have to put it in an indented block where you would indent from the left and the right-hand margins, okay? In the second video that I'm going to record about the mechanics of quotations, we're going to talk about how precisely to do a block quotation. All right, second thing you need to do to avoid plagiarism is to cite the source. And you have to cite a source always when you, first of all, quote language from that source. So whenever you borrow language from a source, put it in quotation marks. At the end of the quotation, you have to give a citation to the source where that quotation came from. The second circumstance is, even if you're not quoting a source, if you're just paraphrasing ideas from the source and those ideas are not your own, you're just putting them in your own words, you still, at the end of the sentence where you have paraphrased those ideas, you have to give the reader a citation. All right, so that may be different from citation conventions or quotation conventions that you're used to in other types of writing. So let's focus a little bit on best practices here. And I think the message that I want to send to you is lots of quoting in a piece of writing makes that piece of writing hard to read. All right, so your preference should be for paraphrasing sources rather than quoting them. So in other words, you should prefer to, if you're going to borrow ideas from a source, put that language, those ideas in your own words, rather than taking the language from the source, the language that describes those ideas, and quoting it in your paper. Why should you do this? Why is this preference one that law trained readers hold? Well, first of all, there's a readability issue. quoted language doesn't engage readers as much as paraphrased language does. And that's so because readers tend to get bored by quotations, especially if there are a lot of quotations in a piece of writing, and especially if there are long quotations. The readers tend to either skim over the quotations or they'll just ignore them. So quoting a lot isn't engaging for the reader. The second reason you should prefer to paraphrase is that you'll be able to communicate your points more clearly, more concisely, and you'll be able to tailor your language to your client's case. Those things are harder to do when you're just constantly borrowing language from a source. Because sources, particularly cases, often aren't, well, I shouldn't say often, but sometimes aren't written well. Either the language is archaic, or it's confusing, or it's wordy. So, and you don't want to do those things with your writing. You don't want confusing language in your papers. You don't want archaic language in your papers. You don't want wordy language in your papers. That's because law-trained readers really want you to get to the point and get to the point quickly. So paraphrasing the sources will allow you not only to avoid wordiness and confusing language, but it'll also allow you to tailor the paraphrasing of the sources to your client's own case, which the cases themselves don't do. Those cases aren't talking about your client's case. They're talking about another case. However, there are times when you have to quote a source. Actually, I shouldn't say have to, but when you should quote a source because it's a good practice. So this is kind of the exception to the general rule of thumb that you should paraphrase rather than quote. So what's the first exception? Well, the first exception is that if you're stating an important legal principle, and I'm sorry, there's a grammatical error on the slide. I should say stating an important legal principles. For example, if you are stating for your reader the rule of law that you're going to apply to your analysis, you should quote that rule because getting the language accurate is important. If the language of the rule that you're stating is not accurate, that could make your analysis inaccurate. The second situation where you should quote a source is when you're stating any kind of important statutory or constitutional language. So in situations where you're applying a statute to carry out your legal analysis, or you're applying part of a constitution to your legal analysis, you should quote the relevant parts of the statute or the relevant parts of the Constitution, because again, you want to get the language correct. If you don't get the language correct, your analysis could be incorrect. So then we come to this point. Why do you need to attribute borrowed language to its source? Why is that required? I mean, why shouldn't we just allow our writers to just borrow language from other sources without telling the reader that it's not their own language? Well, first of all, by properly attributing language to a source, which, as we've talked about, is usually by placing it in quotation marks, that shows the reader that the language that you borrowed is not your own, and it gives credit to the original writer. That's important. You want to make sure that any ideas that you're borrowing from a source are properly attributed to the source so that the original writer gets credit. The second reason is it helps you build credibility. If you're just basically borrowing passages from a source without showing the reader that they're not your own language, in other words, you're plagiarizing, the reader's going to lose trust in you and therefore may not trust the actual substance of your analysis. So properly attributing language to a source by placing it in quotation marks if you're borrowing it builds your credibility. It makes the reader trust you more. That's really important for law-trained readers. So this next question, I guess, could be rephrased as, when do you know that you're actually borrowing language from a source? In other words, when do you have to put that language in quotation marks? So you have a passage in front of you that you put in your paper. You examine that passage and compare it to what's in the source. The main question you have to ask yourself is, how similar is the text in the passage in your paper to the text that appears in the source? The more similar they are, the more likely it is that you're going to have to put that passage, and quotation marks. And gauging the similarity, you could use the following guidelines. The first is, how long is the passage? The longer that it is, the more likely it is that you're going to have to put the passage and quotation marks. So many writers use a 7-word benchmark. So if they have a passage that they've taken from a source and at least 7 words of that passage are the same as what's in the source, they say, okay, I have to put this in quotation marks because I'm borrowing. I need to properly attribute the language to the source. Okay. Now, this doesn't mean that passages shorter than 7 words never have to be in quotation marks. Sometimes they do, which we'll talk about in a moment. The second thing you look for in similarity is, how similar is the text in your paper to the text in the source? Okay. If the sentence structure is more similar, then it's more likely that you're borrowing the language and thus have to put it in quotation marks. So if you have a 10-word passage, for example, and you've changed only 1 word of that passage from what appears in the original source, you're still going to have to put that, probably have to put that passage in quotation marks because you're only changing 1 little thing. Now, there are ways of indicating that change in the quotation, which we'll talk about in the next PowerPoint presentation that I'm going to post for you. But just look at the sentence structure and look to see how similar they are. Finally, there are situations where you might be using a unique phrase that a particular writer coined, particular writer created, and that's well known. Or a particular phrase that's used in a rule of law that you didn't create, but that the court who adopted that rule or the legislature that wrote the statute created. In those situations, you might have to put that unique turn of phrase in quotation marks. So for example, in the discussion 1 case, a turn of phrase that you'll probably use a lot is extreme and outrageous conduct. That's a requirement under the intentional infliction of emotional distress rule. So even though that phrase is shorter than 7 words, the first time you mention it, it should be in quotation marks. And then after that, and this is what's interesting with unique turns of phrase, after you quote it the first time, if it's a short phrase, thereafter, you don't have to keep putting it in quotation marks. You can leave the quotation marks out. Okay, so as we've mentioned already, the preference you should have is paraphrasing rather than quoting. But if you should quote in a situation, for example, if you're stating a rule of law in your paper and you want to make sure you're getting the language accurate, and thus you're quoting the important parts of the rule, quoting the rule, what you want to do is you want to limit the quotations to the key language from the source. So you're not giving the reader lengthy quotations. Again, lengthy quotations in particular cause readers to zone out because they're just not as engaging as language that you've created. So ask yourself, what is the most important language from the source that my reader needs to know? So if you're stating a rule of law, for example, look at the rule, look at the key language of the rule that you need to apply to your client's case and quote those portions. So let's look at an example here. And this should be a familiar rule to you. This is the foreseeability rule for negligent infliction of emotional distress in New Hampshire that the court in Corso versus Merrill adopted. So if you look at this is the direct language from the source. You see that the quotation is rather lengthy. And if you were to quote all of this, you'd have to put it in a block quotation. Block quotations, because they're lengthy in particular, are not engaging for readers. Readers are usually going to gloss over that sort of thing. So what I would recommend is that in looking at the foreseeability elements here of the plaintiff being located near the scene, the plaintiff's emotional injury resulting from the sensory and contemporaneous observance of the accident, the plaintiff and the victim having to be closely related, that you zero in on the exact language you're going to be applying to determine foreseeability and just quote that language. So here is an example of effectively quoting that rule. And you'll note a couple of things. First of all, most of the passage is paraphrased rather than quoted, okay? Paraphrased rather than quoted. And second, the paraphrased portions of the passage are tailored to the client's specific situation. So the rule is phrased in a way that tells the reader what the client has to do in applying the rule. All right, so, and then you see for the three elements of foreseeability, only the critical parts of those elements are quoted. And you're doing that, or the writer here is doing that, to make sure that those portions of the rule are accurate. All right, so you see how this enables you to be more concise, to write in a more engaging way, and to frame the legal principles in terms of your client's case. And that will help the reader understand what you're going to do. So in conclusion here, this slide has some sources on properly quoting and paraphrasing sources. There's a part of a chapter in the Edwards text that talks about the principles we talked about today. Rules 38 through 40 of the Allwood Guide to Legal Citation go into much greater detail about when you should and shouldn't quote and the mechanics of the quoting, which we'll cover in the next PowerPoint presentation. You should have been assigned to complete Professor Martin's Avoiding Plagiarism online mini course. There's a link in this slide to that mini course. If you haven't completed it, I'd highly recommend that you get it done. This PowerPoint, by the way, will be posted on Twin, so you can download it and use that link to get to the mini course if you haven't done it. And finally, I've also posted on Twin a handout that is in table form, and it sort of summarizes the principles that I've talked about in this presentation that I'm going to talk about in the next. So that's a wrap for this PowerPoint on general best practices for quoting and paraphrasing. In the next PowerPoint presentation, I'm going to delve into the specific mechanics of how to quote and paraphrase. So have a good day.